Welcome to this abortion rights talk, a different approach to addressing the abortion and reproductive rights problem using current law. Since the Supreme Court's Dobbs decision, lawyers, political leaders, and activists have been trying to figure out exactly what's going to happen with this issue. Two solutions have floated to the top. The first, expanding the court. Now, this isn't as radical as some would have us believe, as there have been attempts or changes in its number over half a dozen times in its history. The other solution is compromise legislation from Congress that would codify abortion rights into federal law. Now, this would be challenged by conservative states, of course, eventually winding up with the very same court that gave us Dobbs. With the current shape of Congress, neither of these solutions is likely. However, there is another, potentially more effective and comprehensive strategy and solution which isn't being discussed. It requires no new federal laws, policies, or amendments, doesn't matter the configuration of Congress or who the president is, and it does not interfere with any other strategies. All that is required is a fair, consistent application of current laws and honest interpretation of constitutional rights. This strategy and solution has at its foundation one goal and one goal only: complete and total bodily autonomy. Now, this should be at the core of any legislation coming out of Congress: complete and total bodily autonomy. No compromise. Now, when some hear the words no compromise, they see it as radical and non productive, that there must be some sensible middle ground that we can all agree to. There isn't. And there are a number of reasons for that. First, any compromise is neither fair nor equal. For all intents and purposes, men have complete and total bodily autonomy. Medical issues with men are between doctor and patient. The state's only interest is in the safety and legality of the treatment being offered. There are no preventative laws getting in the way of access to available procedures, and this should be true for women. Any compromise is saying that women cannot be trusted with this life and death decision without government oversight, that they will be irresponsible. This is insulting. It is not reasonable to believe that men are better at life and death decision making than women. And we have an entire military industrial complex that demonstrates the irresponsibility of men on this point. Another reason there can be no compromise is that we've already had one, and it's failed. Roe v. Wade was the compromise, and anyone that says that it was radical and all they're looking for is a reasonable middle is being disingenuous. Roe v. Wade gave us the trimester guidelines based on fetal viability, where a woman in consultation with her doctor had complete and total bodily autonomy over the first 13 weeks of her pregnancy. The last 13 weeks, states could pretty much ban abortion except in the cases of rape, incest, and maternal health. The middle 13 weeks was a mix, with states being able to intervene, usually for reasons of maternal health. What this meant was that women had total decision over the 1/3 of their pregnancy, while states could intervene to varying degrees over 2/3. But this 1-to-2 ratio was not enough. As we have seen over the last 50 years, access to abortion procedures has been eroded. Now, a number of legislators want to codify Roe into federal law, and this should be avoided. Not just because any compromise is insulting to women or that it allows an unfair degree of intervention by states, but to codify the law is to formally place women in a second-class status, and that should not happen. The last reason there can be no compromise is that the faction against abortion and reproductive rights simply cannot do it. Any pro-life individual or organization that says they're just looking for a reasonable middle ground is not being honest with you and or themselves. If they are sincere about their beliefs, they cannot compromise on this issue, and not for any extreme or radical reasons. It's perfectly understandable. If we have any empathy or compassion at all, we know what it's like to hold a baby in our arms, have it look up, smile at us, reach out, cute, helpless, to feel the outrage of any situation that would place these fragile creatures in harm's way. Many of us are able to compartmentalize, differentiate between the developmental stage and the baby we are holding in our arms. However, if you cannot make that distinction and your emotions go all the way back to conception, then you cannot compromise. Not for 20 weeks, 13 weeks, 6 weeks, not a single week. Of course you can't. So, what does that leave for the pro choice faction if compromise is off the table? Which it is. Well, two things basically. One, capitulate. You throw up your arms, say, I'm tired of beating my head against this brick wall, and I'm going to spend my time and energy teaching sex education and the availability of birth control and contraception. And anyone that falls between the cracks, hopefully there will be something there that will help them. Or two, you can do what your opposition is doing. If you believe that the woman has the right to make this decision in this complex situation, then you have to dig your heels in and fight. And there can be no compromise because your opposition won't let you. So, if complete and total bodily autonomy is the goal, what is the solution that gets you there? It can be summed up in one sentence. Our courts need to be made to establish the specific constitutional legal status of the fetus. Again, our courts need to be made to establish the specific constitutional legal status of the fetus, to legally determine whether it is a person or not. This goes directly to constitutional rights. If it's a person, it has them. If it's not, it doesn't. Our courts and institutions have been allowed to get away with a fuzzy, indistinct middle because of how we feel about babies and pregnancy, taking advantage of our emotions and attitudes concerning Christian morality, playing fast and loose with the laws. And this needs to cease. So, if the states have to make that distinction, what does that mean? Well, let's take a look at what is the current actual legal status of a fetus. And that is, it is not a person. At no time in American history has the fetus been given legal personhood. Oh, I know there's always talk about it. There's talk about it now, but it has never happened, not in any state. No secular institution of any importance has ever treated the fetus as a person. Not taxes, social programs, birth certificate, driver's license, pick your institution, they all start at live birth. The court in 1973, in its Roe decision, looking back on America's legal history, stated that they were not establishing personhood with this ruling. Now, what that means is they weren't taking anything away. What they discovered is that the fetus was never given personhood and wanted us all to know that they weren't giving it. And let's be clear, the word is person or people, not human or human beings, as many states want to work themselves around to. In law, human is not a euphemism or substitute for person, and our framers demonstrated that. For example, in the compromise, it was 3/5 of a person, not 3/5 of a human. The current conservative Supreme Court, given an opportunity to establish rights for the fetus, refused to do so. So, if the fetus is not a person and has no constitutional rights, what does that mean? Well, one of the things it means is if you're ever in a conversation on this issue and someone says, well, you're always talking about the women's rights. What about the rights of the fetus? Well, they don't have any. Also, what this means is that a woman's pregnancy is legally a medical condition, and that the state should have no more interest in that medical condition than any other. In fact, the state's priority should be to the group with constitutional rights, not the group without them. And so the woman, in consultation with her doctor, should be able to access safe, approved legal treatment for her condition. She gets to decide what happens with her pregnancy under current law. But let's talk a minute about one of the things that the Dobbs decision does that's dangerous. I'm not talking about what Clarence Thomas has said about Obergefell and same-sex marriage or going back to Brown v. Board of Education. Those are different rulings, different cases for different times. I'm talking about what Dobbs potentially does right now. And what Dobbs does, in effect, is give the states the power to take a group with no constitutional rights and give it some special, superior rights, where this group has the ability to use the body of another group that has constitutional rights for its own benefit for as long as it needs to. This is in complete violation of the 14th Amendment, and given the reason the states are doing it, a potential violation of the 13th Amendment. Not only that, these special superior rights are automatic. No legislation is required to receive them or to lose them. It just happens. Now, what this also means is that only one group gets to enjoy these superior rights. Once again, in complete violation of the 14th Amendment. But of course, with Dobbs, why should they be temporary? If the state can give superior rights, it can decide whatever group it wants. White people have superior rights over black people and can use their bodies for as long as they need to for their own benefit. Men have superior rights to women and can use their bodies for as long as they want to for their own benefit. The states could give rights to your livestock or your pets. The dangerous thing, one of the dangerous things that Dobbs has potentially done is allow the states to bestow group supremacy. So, to synopsize, if the fetus is not legally a person, which it's not, it has no constitutional rights. A woman's pregnancy is a medical condition. The state should have no more interest in that medical condition than any other. She is allowed to access safe, approved legal treatment and consultation with her doctor. In short, she gets to decide what happens with her pregnancy. And this is all under current law.